Okay, we're live.
Okay. Well, hello, and thank you for joining us for this evening's webinar, Elections, Lawsuits, and Voting Rights in the Time of Pandemic, where we've been and what lies ahead for Wisconsin. This webinar is presented by the Wisconsin Interfaith Voter Engagement Campaign, which is a project of Wisconsin Faith Voices for Justice and the Wisconsin Council of Churches. You can learn more about the campaign by following the URL link in the chat box. I'm Peter Bakken, Justice and Witness Coordinator for the Wisconsin Council of Churches. And on behalf of Rabbi Bonnie Margulis, Executive Director of Wisconsin Faith Voices for Justice, and myself, welcome to tonight's presentation. In tonight's webinar, we will learn about some current Wisconsin court cases involving elections, voting rights, and redistricting. We're extremely pleased and honored to have as our presenters two lawyers who have been deeply involved in these cases. Doug Poland is the founding member of Rathje Woodward's Madison office. Jeff Mandel is a partner at Stafford Rosenbaum. We've muted all the participants and turned off video sharing to make it easier to focus on the presentations. We'll have time for questions at the end of the webinar. If you're on Zoom, please enter your questions in the chat box at the bottom of your screen, the little word balloon. If you are watching on Facebook Live, please enter your questions in the comments. We will relay as many questions to our presenters as time permits. And now, I happily turn the webinar over to Doug and Jeff.
Peter, thank you so much for that introduction. Thank you to you and to Bonnie and to the Interfaith Voter Engagement Campaign for providing this opportunity for Jeff and I to present this program. Wanted to start out just a little with a very brief, I guess, explanation of the faith grounding that I have for this work that I feel called to do. And make no mistake about it, it is a calling. I feel deeply called. I feel compelled. I don't feel that I have a choice in this and have a very strong faith basis for doing this type of work. And I'm going to refer to just a couple of passages of scripture that are meaningful to me in doing this work. The first is from New Testament, the Gospel according to Luke. And the passage says, once Jesus was asked by the Pharisees when the kingdom of God was coming, and he answered, the kingdom of God is not coming with things that can be observed, nor will they say, look, here it is, or there it is. For in fact, the kingdom of God is among you. Luke says it's among us, but other gospels, such as the Gospel of Thomas, say the kingdom of God is within us. And the common point in both versions is the focus is on us. Thomas focuses on us as individuals, and Luke emphasizes us as a community. Read together, the point is that God's kingdom is alive and working within each of us individually, but also among us corporately, or as the Apostle Paul, or as St. Paul to Catholics puts it, now you are the body of Christ and individually members of it, from his letter to the Corinthians. In other words, we're an integral part of God's kingdom on earth. And as Christians, we believe that that kingdom began to come into being with Jesus' birth, death, and resurrection, and continues to come to fulfillment through the work of each of us individually as disciples and corporately as a Christian community. To bring it a little bit more contemporary in time, I am really moved by some of the writing and the work of Dietrich Bonhoeffer, who hopefully needs no introduction. But Bonhoeffer, in his commentaries on the cost of discipleship, takes the scripture passage from the Gospel of Matthew, where Jesus teaches that you are the light of the world and you are the salt of the earth. And Bonhoeffer says, note, Jesus doesn't say you are to be the salt of the earth or you are to be the light of the world. Jesus says that we are already both. And to quote Bonhoeffer, he says the flight into the invisible is a denial of that call. A community of Jesus which seeks to hide itself has ceased to follow him. And so that is the kind of calling that I feel compelled to do. That is one of the reasons why I feel compelled to do the work, not just legal work for myself or for my clients, but really to the entire community of people in Wisconsin. All people, not only all citizens, but all residents, everyone who lives within the state. And with that, I'll turn it over to Jeff.
Hi, everybody. Thank you for
having us tonight. It is a great honor to be here, and it's always fun to get to do programs like this with Doug. You know, Doug and I come from different faith traditions, but we have become fast friends over the last few years as we've encountered each other in this democracy work here in Wisconsin. And I think that one of the reasons that Doug and I find so much common ground is not only through the litigation, but because we both do feel compelled to do this work coming out of our own faith traditions. I grew up an active participant and member of the Reformed Jewish movement. I spent 2 years early in my career working at the Religious Action Center in Washington, D.C. On religious left issues. And here in Madison over the last 5 years, my family have remained very active in the Jewish community and are active members of Beth Israel Center. Like Doug, I find a great deal of grounding, in that tradition. My older child, our daughter Micah, is of course named for the prophet who told us that we must act justly, love mercy, and walk humbly with God. There is a piece of art on the wall of my office with the famous lines from the Bible about pursuing justice and the essential role of that in our world. And when my wife and I moved here to Madison, really with no connection to Wisconsin about 5 years ago, one of the things that we decided that we were going to do was make sure that I built into my practice the opportunity to help make sure that our city and our state that we had sort of adopted was going to have the values and reflect the values that we wanted to see in the world for our kids to grow up. And that has unfortunately been more necessary in the last few years than I had fully anticipated. I've been really fortunate to have the opportunity to do that work, and I've been particularly fortunate in doing that work to have the opportunity to get to know and work closely with Doug. And we're going to talk a little bit about some of the work that we've been doing and that we see on the horizon between now and November 2020, and then looking a little bit beyond. At the end, we want to talk about the redistricting process in 2021. So let me start. We're going to cover 4 different areas tonight. Let me start with litigation about the election and about making sure that everyone in Wisconsin has the opportunity to vote safely and fairly. There is, unsurprisingly right now, a tremendous volume of election litigation in Wisconsin. Keep in mind that Wisconsin, alone among all the states, we were the only ones who chose to hold an in-person election right in the teeth of the COVID-19 shutdowns. That led to litigation. So the first group of cases I want to talk about are 3 consolidated cases that, next slide. 3 consolidated cases, there we go, that were brought here in federal court in Madison, in the Western District of Wisconsin, seeking relief for the April 7th election. The first is the Democratic National Committee versus Bostelman. Second is Geer versus Knudsen, and the third is Lewis versus Knudsen. At the time that these cases were brought, Dean Knudsen was the chairman of the Wisconsin Elections Commission. Marge Bostelman is the member of the Wisconsin Elections Commission whose name comes first if you were to list all the members alphabetically by last name. So you're going to notice that a lot of these cases are either versus Bostelman or versus Knudsen. There's really no distinction. These are all cases where people are suing the Wisconsin Elections Commission, which is the bipartisan entity here in Wisconsin that oversees our election law and how our elections are administered. Keep in mind that as a general background, Wisconsin has the most decentralized election procedures and administration in the entire United States. So whereas lots of states have their elections that are really run at a state level, or some states have elections that are run on a county level, here in Wisconsin we have elections that are run on a municipal level. So there are 1,850 municipal election administrators around the state of Wisconsin, each of whom run elections for their municipality, and they report results up to 72 different county clerks who coordinate and collate those results and then share them with the Wisconsin Elections Commission. The Elections Commission is only a couple of years old. It replaced the Government Accountability Board. That's a lot more history than we need to get into. But so we had three cases. The Democratic National Committee sued. They were the first to sue about the April 7th election, and the first thing that they won was they got the federal court to extend the online deadline for registering to vote for the April 7th election. They were soon joined by the plaintiffs in Geer and the plaintiffs in Lewis. The Geer case was a very narrow case brought to challenge the witness requirement for absentee ballots. To cast an absentee ballot under Wisconsin law, you need voter ID to get a ballot. You then need to complete the ballot. You need to sign the ballot, and you need a witness who is an adult United States citizen who knows you and is not running for office to witness that ballot. And so the Geer case was saying that in light of COVID-19, the witness requirement should be relaxed. And then the Lewis case was brought by Souls to the Polls and others, and it actually was the first case that really sought to postpone the April 7th election because of everything that was happening with COVID-19. The court consolidated those cases. That is, it decided to address them all together. And ultimately, those cases did get some relief. They did not get the delay of the election that the Lewis plaintiffs and ultimately the DNC sought, but they did get some relief from the witness requirement, and they got a one-day extension of when you could request an absentee ballot, and they got a 6-day extension on how you could return an absentee ballot, so that absentee ballots could be returned until the Monday after the election instead of having to be returned on Election Day. That case went up very quickly on appeal. The Seventh Circuit Court of Appeals struck the relief on the witness requirement, and then the case went up to the U.S. Supreme Court. And the night before the election, the U.S. Supreme Court narrowed the relief with request to returning ballots after Election Day. It said that they could still be returned up to 6 days after Election Day, but only if they were postmarked on or before Election Day. Next slide. There were three other cases that were brought for the April 7th election that are at least worth mentioning. The first was brought by the city of Green Bay, and it was seeking a delay in the election because the city did not have enough poll workers and felt that it couldn't administer a fair, safe election. Note that the city wasn't necessarily wrong. They ultimately were able to operate only 2 out of the 31 polling places that they would usually operate on Election Day. But that case was dismissed because, for sort of technical legal reasons, there is a lot of law about how cities cannot sue the state or state entities, and so that case didn't make it very far. Taylor versus the Milwaukee Elections Commission was filed by Lena Taylor, who was running for mayor of Milwaukee, and she wanted the election postponed, at least in Milwaukee, because there were going to be so few polling places open in Milwaukee, and she was particularly concerned that there weren't polling places in parts of the city where she lives and where she felt that a lot of her supporters lived, and that case ultimately failed. The federal court in Milwaukee denied the injunction that Lena Taylor had asked for, and there are some lessons to be drawn in that case about making sure you ask early and making sure that your papers are all in order, because one of the things the court said was that they had a lot of trouble figuring out exactly what Lena Taylor was asking for and the basis that she was putting forward. And so on that basis, the court basically dodged the question and denied the relief. The last case on this slide, Wisconsin Legislature versus Evers, was the only case thus far about the election in Wisconsin this year. that was in the state courts. And as you might remember, after the legislature refused to meet and talk about changing the April 7th election date or procedures, and after the federal court granted limited relief, but itself declined the Lewis plaintiff's request to postpone the election, Governor Evers issued an executive order seeking to extend in-person voting until sometime later when the COVID crisis would hopefully be better, and allow people to vote absentee in the meantime. The Wisconsin legislature immediately asked the Wisconsin Supreme Court to step in and shut down that order, basically issue its own order that said that the governor's executive order was without effect, and the Wisconsin Supreme Court did so. It was a fascinating few hours in there. I was actually working on the governor's team on that. Doug, for his part, was working both with the Geer plaintiffs and the Lewis plaintiffs. Next slide. Now we're looking at cases that are focused on the upcoming elections. Obviously the big one on November 3rd, and please don't forget that we have a partisan primary here on August 11th. So these are cases that are still active. Note that 2 of them are cases we've already talked about, the DNC case and the Geer case. In both instances, the plaintiffs have amended their complaints and are asking for new relief for the fall elections. And I'm going to turn it over to Doug and let him quickly talk about the last 2 cases because I've gone over my allotted time here. The Edwards case and the Swenson case in which he and I are collaborating. You're muted, Doug.
Thanks, Jeff. There are two other cases that appear on the screen in front of you. One is called Edwards versus Voss, and that is a class action case that was filed by a number of voters who were in Milwaukee. They filed it right around the time of the April 7th election. It's a little bit different in character because it actually seeks money damages and is brought among a number of different defendants or against a number of different defendants, including the Assembly Speaker Robin Voss and also the Senate Majority Leader Scott Fitzgerald. But it is a little bit different in its character than some of the other cases. The final one is Swenson versus Knudsen. Jeff and I are co-counsel on that one, along with a large national law firm called O'Melveny & Myers and a national group called Protect Democracy, which is a nonprofit that seeks to bring claims around the country that involve essentially general principles of democracy. And we also have a lawyer who's working with us who's at the MacArthur Justice Center at Northwestern University. That case is much more like the Geer case, the Knudsen or the DNC case, and in the Lewis case, in that it seeks really draws on the April 7th election and a number of the problems that were encountered during that election, and seeks a court order putting in place safeguards that would ensure as much as we possibly can that the difficulties that caused literally tens of thousands of voters in Wisconsin to be disenfranchised with respect to the April 7th, the spring election, to try to make sure that they are not disenfranchised in the coming elections. And so that could be voters with disabilities who had problems voting. It could be people who are immunocompromised. There are a number of different categories of voters who are unable to vote, whether in person or by absentee. And so we're seeking injunctions, orders from the federal court that would require the Elections Commission to make sure that it's got safeguards in place that allow everyone who wants to exercise a vote to be able to do that. And with that, why don't we go on to our next category, then if we could see the next slide. And that is the voter purge litigation. Voter purge is a little bit of a shorthand for a couple of different cases that have been going on since November of last year. You may have read something about these cases in the newspaper, referring to voter purge. So the first of the cases is called Zignego versus the Wisconsin Elections Commission. And it was a case that was filed in Ozaukee County Circuit Court last November. Let me give you a little bit of background, though, on really what we're talking about here. So Jeff had mentioned the Elections Commission before. The Elections Commission, among its different responsibilities, is tasked with compiling and maintaining an official voter registration list electronically. The list is maintained on WISVote, if any of you have been to the website, and hopefully all of you have. That's the way that we manage the voter registration system statewide. Only the Election Commission employees, municipal clerks, and election officials who are authorized by municipal clerks are allowed to make changes to the list of registered voters on WISC. And that's by statute. Revision of the list is required under certain circumstances, and one of those circumstances is when an elector or a voter hasn't voted in the previous 4 years. So the commission is required to examine the registration records for each municipality and identify each elector who's not voted within the previous 4 years, if they were qualified to do so during that entire period. They then have to mail a notice to the elector notifying them that their registration will be suspended unless they apply for continuation of registration within 30 days. A little pro tip here to all of you, check the MyVote website frequently to make sure that your registration is current at the address at which you currently live, especially for those of you who might be students or who might move around a little bit. Another circumstance that requires revision to the registration list, is when the municipal clerk or board of election commissioners receives quote unquote reliable information that an individual elector has changed his or her residence, has changed their residence. So let me go back to 2015 now for just a little context. In 2015, the state legislature directed Wisconsin to join something called the Electronic Registration Information Center, or ERIC for short. You might have seen the reference to this acronym ERIC in some of the newspaper articles. And ERIC is really it's a system that is maintained. It's a consortium actually of 28 states in the District of Columbia. They share data about voters among each other, among the states, to help improve the accuracy and efficiency of their voter registration system. So ERIC is actually, it's a good thing that Wisconsin is involved in it. So ERIC helps its members to identify people who might be eligible to vote, but who haven't registered, voters who might have moved since their last registration date, voters who are deceased, who might have voted in the same election more than one state, voters who might no longer be eligible to vote. So ERIC does this by comparing data about registered voters with information from other sources, like the Division of Motor Vehicles and the United States Postal Service. So there's a membership agreement that the state of Wisconsin has with other ERIC members, and it requires states, including Wisconsin, to transmit data relating to the registration of voters in the state to ERIC, and that then gets shared with the other states. So in 2017 was the first time that ERIC actually shared data with the state of Wisconsin. And what the data that ERIC provided to the state showed that approximately 341,000 registered Wisconsin voters might have moved their home address based on information that ERIC had compiled. So the Elections Commission, then this is back in 2017, mailed a postcard to these identified voters, these 340-something thousand voters, directing them to re-register if they had moved, or to sign and return the postcard to their municipal clerk or the Board of Elections Commissioners so they could keep the registration current. Following that mailing, the Elections Commission identified a number of discrepancies that caused voters to appear in the list of movers, even though they may not have moved. In January 2018, the Elections Commission deactivated the voter registrations of voters who hadn't returned the postcards. And so voters whose postcards were returned as undeliverable were also deactivated. In all, 335,000 voter registrations were deactivated. I mean, that's a tremendous number. That's about 10% of the number of registered voters in Wisconsin. And so the deactivation of that, mass deactivation of those registrations caused all sorts of problems for the 2018 spring primary because, of course, a number of those people had not moved. These were false positives that were identified. Long story short, there was a reconsideration of that process that was used. And so following the 2019 election, the Elections Commission decided that they were going to do things a different way. They decided that rather than send out that postcard and immediately deactivate people who hadn't registered or who hadn't responded within 30 days, they were going to take a different process. And so they decided that they were going to send out a new letter, and they did that in October of 2019. And so they mailed out letters to 234,000 voters who might have moved based on a new list that they got from ERIC. But instead of telling the voters they were going to deactivate them, they simply asked them to respond to the postcard that was the letter that was mailed out and to go to the MyVote website and to change their registration or re-register, but to respond in some way. But, and this is critical for the purpose of this litigation, they did not tell the voters that their registration would be deactivated. Well, fast forward to then to the Zignego case, which was filed in November of 2019. There were three voters in Wisconsin, 3 residents. They filed a lawsuit in November of 2019, and they filed it in Ozaukee County Circuit Court. And these voters, who were represented by the Wisconsin Institute for Law and Liberty, or WILL, which is based in Milwaukee, they said, look, there's a statute, and it's section 6.50 sub 3, which is a category of the Wisconsin statutes, that says that if reliable information is furnished that a voter may have moved their address at which they are registered, then the municipal clerk or board of elections commissioners is supposed to notify the electors by mailing a notice. And if there is no response within 30 days, their activation or their registration should be deactivated. That's the statute that Will argued applied and should be applied by the circuit court, and that the people who hadn't responded should be deactivated. There was a hearing that was held in Ozaukee County Circuit Court on December 13th, and the judge in Ozaukee County ruled that that statute did in fact apply, and issued what we call a writ of mandamus, which ordered the circuit court judge to deactivate those registrations. The case then was appealed to the Court of Appeals in Madison, District 4. Will sought to take the case up immediately to the Wisconsin State Supreme Court. The Wisconsin State Supreme Court declined to hear the case. Instead let the Court of Appeals issue a decision, and the Court of Appeals in February ruled that that statute 650 sub 3 did not in fact apply to this particular procedure that the Elections Commission used. It actually only applies to municipal clerks and to the Milwaukee County Elections Commission. And so it did not require the Wisconsin Elections Commission, the statewide body, to immediately deactivate those registrations. Will then filed what's called a petition for review to the Wisconsin State Supreme Court. The Wisconsin State Supreme Court just accepted that case for review on June 1st, and it's actually in an accelerated briefing schedule right now. There's a chance that the case might be heard by the Wisconsin State Supreme Court still in June. There's a chance that it may not be heard until after August 1st. The reason that's important is that as of August 1st, the Supreme Court will have a different makeup. Justice Kelly will no longer be serving on the court as of July 31st. And as of August 1st, Justice Karofsky will be serving. So we'll have a different makeup on the court. So there is the Supreme Court still hasn't decided when it will actually rule in the case, whether it will be before August 1st or after August 1st, but we're waiting for that. Very quickly, there was a second case also that was filed, League of Women Voters of Wisconsin versus Knudsen. I was one of the lawyers in that case. We filed that case in the federal court in December of 2019. We had sought to intervene in the Zignego case in the circuit court, but the circuit court judge did not allow us to intervene. We then filed the case in the federal court based on the federal due process clause of the United States Constitution. And the argument there was that if the Elections Commission in fact decided it would immediately deactivate the registrations of the Wisconsin voters as required by the circuit court, that would be a violation of the due process clause of the federal Constitution, and that the federal court should enjoin that from happening. Because the case has been proceeding in the state courts, though, and there's no final decision as to whether those registrations should be deactivated, the federal court dismissed the case in April, but it did it with what we call without prejudice, which means that if the Wisconsin Supreme Court once again rules, whether that's in June or July or August, that section 6.50 sub 3 does require these registrations to be deactivated, then we could refile our federal case and ask that order be enjoined, or ask that the Elections Commission be enjoined from deactivating those registrations. Let me turn it back over to Jeff then to see if Jeff has any comments on that.
Let me just quickly add that This is a great example of how Doug and I have tag-teamed things. He represented the League of Women Voters, and when they were denied their intervention in the trial court matters in the state courts, I, working with the Service Employees International Union, got involved in the Court of Appeals and the Supreme Court, and both Doug's clients and my clients, I expect, will be filing briefs in the Supreme Court fight. I would just note two quick things that are important about this case. You will hear from the plaintiffs and their lawyers about what an outrage it is that the Wisconsin statutes expect these people who have moved to be stricken from the lists, and how truly outrageous they find it that the Wisconsin Elections Commission hasn't done so. But I would note that if you were listening carefully to what Doug said when he quoted Wisconsin Statute 6.50, subdivision 3, what it said is that if there is reliable information that a voter has moved, the municipal clerk will remove that person from the voter rolls. In other words, it's not the Wisconsin Elections Commission's job on a statewide basis to handle these movers. It is the job, according to the legislature, of individual municipal clerks. And so a great deal of the high dudgeon that the plaintiffs are in about how the elections commissioners are deliberately defying the law, the reason the Wisconsin Court of Appeals ruled against the plaintiffs and said that these people did not need to be stricken from the list, the primary reason is it is not the job of the Wisconsin Elections Commission. In fact, the Wisconsin Elections Commission does not have the power to take these people off the list. Only local municipal clerks do. You might think that that's a strange thing or an oversight, but it's really not, because one of the other things that's in that statute is that you only get removed from the list if you move outside of your municipality. If you live within your municipality and you move to a different address down the street, around the corner, even in another precinct within your municipality, the clerk is just supposed to update your address and make sure you're voting at the right precinct. You do not have to be taken off the list and re-register. And this is another issue that the plaintiffs are just blatantly ignoring. Some substantial number of these people, both of the 350-odd thousand people who were removed previously and of the 250-odd thousand people who are the subject of this lawsuit, some substantial number of those people simply moved within their municipalities, and they should not be subject to removal from the list at all. There's also some number of these people who just didn't move, as Doug noted. And one of the major disputes in this case is about whether the ERIC data is reliable for this particular purpose. There are lots of ways in which it is reliable, but there are also plenty of reasons to think that this is not particularly reliable information of where people reside and intend to vote. So as with so many of the cases about this area of the law, there's a lot more going on sort of underneath the hood than it might look like. Let's turn briefly to a third topic, and then I'm going to send it back to Doug. The third topic is a new matter that has been brought forward by the same law firm, the Wisconsin Institute for Law and Liberty, which is sort of a conservative impact litigation firm. It's an organization in Milwaukee. It's about 9 years old now, and all they do is bring lawsuits to advance more conservative law in Wisconsin. In this particular issue, which they call ballot harvesting, but I would prefer to call ballot collecting, they have asked the Wisconsin Elections Commission to undertake regulation and make some rules. And this is an issue somewhat like the voter purge, where what they've asked sounds on its face to be somewhat reasonable until you actually give it a little bit of extra thought and you look at the statute. This was filed on June 8th on behalf of 5 people, and what they want is emergency regulations to be adopted by the Elections Commission that say that it would be unlawful for any individual in the state of Wisconsin to request an absentee ballot for someone else or to return an absentee ballot for someone else. And, you know, that might, on first blush, sound kind of reasonable, but I actually would suggest to you that it really isn't. First of all, I want you to think about what it takes to obtain an absentee ballot in the state of Wisconsin these days. You either need to go to a polling place or to City Hall with your ID to obtain an absentee ballot, or you can do so through the MyVote computer system that Doug mentioned earlier. But if you're going to do so through the MyVote computer system, you need to be prepared to upload into that computer system a scan of your photo ID that meets the voter ID standards. So for most people, that's going to be a scan of your driver's license or a photo of your driver's license. Now, for some of us who use smartphones every day and are fairly facile with technology, that is not particularly difficult. And the system can, at times, actually work quite elegantly and well. But for people who are not used to using such technology, or for people who don't have access to such technology, or just struggle with, you know, getting the photo, holding the phone steady enough to get the photo of their ID that's clear and things like that, this is incredibly difficult. And the idea that it would be unlawful for someone to help another registered voter do that seems a little bit crazy. I'll also confess here that if the plaintiffs were correct about what the law is, I would have violated it this past April, unknowingly, but nonetheless. You know, as you remember, many of us were significantly curtailing our activities due to the risks of COVID-19. My wife and I both received absentee ballots. My wife preferred not to put hers in the mail, and so she suggested that I should jump in the car and run downtown and return both of our ballots to City Hall. According to the rulemaking petition that Will has put forward here, that in itself would be against the law. Both my wife and I would have violated the law, though the ballot she gave me, to be clear, she had already voted, she had sealed the ballot into her envelope, she had signed the envelope, and it had been witnessed by an adult. But just giving it to me and asking me to return it to City Hall would have violated the law. We then violated the law another way, because as I walked out to the car to go do this, a neighbor went by on her bike and said she was going downtown to return her ballots, and she was happy to take ours. So I gave them to her. Someone I know very well, someone I trust, and had no doubt the ballots would get there. That too, according to this rulemaking, would be against the law. And I would suggest to you that all of this is ridiculous. I would also suggest to you that it's quite possible my neighbor independently violated the law, according to this rulemaking, because she did not hand the ballots to the Madison city clerk, who is wonderful if you don't know her, Mary Beth Wetzel-Beal. Instead, there was somebody standing out on Martin Luther King Street in front of City Hall collecting these ballots, a city worker who was working as a poll worker that day, collecting ballots for people who are doing exactly this, so that people did not need to go into City Hall. But as I read the rulemaking petition, it says that if you return your ballot to anyone except for the city clerk, you have violated the law. All of this strikes me as ridiculous. It's based on fear-mongering about the idea that there might be some advocacy group or some other group out there that would go around and collect hundreds, if not thousands, of ballots and somehow try to alter them or try to figure out who each ballot is cast for and discard ballots that they didn't like who they were cast for. But there is no evidence that any of this has ever happened in the state of Wisconsin. This is really nothing but fear-mongering. And if you look at the statutes, the actual text of the law that Will is basing this on, it doesn't say what they say it says. It simply doesn't. And in fact, the Elections Commission staff looked at this issue several months ago, issued a memo explaining that the law did not go as far as to prevent some of the things that advocacy groups out there wanted prevented. And there was a bill introduced in the legislature this last session to tighten up this law and come very close to what this rulemaking petition is asking for. But that bill did not pass the legislature. It is not the law. And so this is an example of how people can bring these actions, especially particularly close to the election, in hopes that they can get some headlines and really change the law without going through the processes that are necessary. This is pure speculation, but my best guess is that the Wisconsin Elections Commission will not adopt the regulations that are asked for here, and it's possible that that the Wisconsin Institute for Law and Liberty will then file some kind of lawsuit, but I actually don't think they're very well positioned to succeed on this one, either procedurally or on the merits. So I think this might be a whole bunch of, noise. Let me turn it back to Doug for any comments he has on that one and our fourth topic before we take questions.
Thanks, Jeff. Really quickly, before I get into our last topic, I just wanted to mention this. What Jeff just addressed, the ballot harvesting measure, is something that supposedly is presented as something necessary to prevent voter fraud. Whenever you hear the term voter integrity, it essentially means the same thing as voter fraud. Chris Kovach, who you've probably heard about in conjunction with this voter fraud commission that President Trump had ordered to go forward with its work. This idea of voter fraud is something that people like to trot out. What I'd like to impress on everyone is that what the case law says, longstanding Supreme Court case law says, is that state governments have interests certainly in preventing voter fraud. That's one of the two main interests that states have had since the founding of the Republic. But there's another consideration that states have, and it has equal weight, and that is preventing voter intimidation. And so as much as states have an interest in trying to prevent voter fraud, and make no mistake, as people have probably heard time and time again, there is almost no voter fraud that occurs. The studies that have looked at it have found infinitesimal amounts of voter fraud that happens. By contrast, voter intimidation, whatever the form may be, whatever the form of voter suppression takes, it is alive, it is well. We hear certainly the talk of the new Jim Crow. We see it in action. We see it in action down in Florida, where even though the voters in the state of Florida decided overwhelmingly that convicted felons, once they're done, once they're off paper, they should be entitled to vote again. The state went forward and it imposed some additional, what was just held last month, to be a poll tax. And so voter suppression is alive and well. And so states are not living up to their obligation to try to prevent voter intimidation. Instead, they're putting their thumb on the scale on the voter fraud prevention side. And that's what we see in a lot of things that happen in Wisconsin, both by governmental actors and by non-governmental actors too. So with that, let's get on to our last topic here. And if we could have the slide advanced to the next slide. Will has certainly been busy. Not only on June 8th did they file the petition Jeff just talked to you about, but on June 2nd, they filed what Patrick Marley in the Journal Sentinel called the opening shot, or I think he called it the opening shot of redistricting that is going to be coming next year in 2021. As people probably know, in census years, so there's the decennial census. The last one we had was in 2010. The census is currently going on right now. We'll have census data at some point next year between March and July, depending on when they finally decide the census is complete, and that's in a little bit of a state of flux right now. But we'll have a census then, and we'll have new data for who lives where within each of the states. Based on that data, the states have to come up with new state legislative districts, so new assembly and senate districts. We have 99 assembly districts in the state of Wisconsin. There are 33 senate districts, so there are 3 assembly districts to every single senate district. That redistricting also will come up with new congressional districts for the state of Wisconsin as well. So that happens every 10 years. It happened in 2000, and shortly after it happened in 2000, and there are always lawsuits that are brought over these. Historically, these lawsuits have been litigated in the federal courts. Well, in 2002, they were again litigated in the federal courts, and there was a petition that was brought by Scott Jensen, a Republican in Wisconsin. And he asked for procedures. He asked the Wisconsin Supreme Court to establish procedures for redistricting litigation because there weren't any procedures, and that's one of the reasons that this has always been done in federal court. The Supreme Court appointed a study committee in 2003, and after years of study and a proposal of recommendations from a committee, in 2009, the Supreme Court rejected the committee recommendations, and it essentially went nowhere. Nothing was done. In 2011, there was a new redistricting. We actually litigated that. I was one of the lead trial lawyers in that case. We litigated in federal court in Milwaukee. In 2012, we had a trial, and there was a final decision by the federal court in Milwaukee that resulted in an invalidation of two districts in Milwaukee over a violation of Section 2 of the Voting Rights Act. And those districts were reworked by the court. Otherwise, the districts as enacted by the legislature stayed intact. So that's where we were back then. So just a couple of weeks ago now, Scott Jensen, represented by Will, filed a new petition with the Wisconsin State Supreme Court, asking the state Supreme Court to adopt a set of procedures that would apply to any litigation over redistricting that's filed in the state of Wisconsin. It's a short petition that was filed. It's only a few pages long. The procedure now is that the Supreme Court, it's up to the Supreme Court to set a hearing date, to take testimony, to take comments, and to hold a hearing on it. We don't yet have any kind of a schedule for when that's going to happen. And we might or might not get a schedule, but I would anticipate we'll get one at some point sometime soon. I wanted to focus just very briefly on a couple of the substantive points of the petition that Scott Jensen and Will submitted. First of all, as you note from the timeline that's in front of you, it was 2002 that Jensen filed the petition, and then 2009 when the Supreme Court rejected the committee recommendations. There was 6 years of study there by a committee, and they couldn't adopt the recommendation. Here, there's an attempt to rush this through very quickly, we can't expect that this can be done in a very high-level quality way to be implemented anytime soon, especially not before the next round of redistricting takes place in 2021. Go to the next slide, please. Second of all, the petition proposes jurisdiction that would be solely in the Wisconsin Supreme Court, and it's discretionary jurisdiction. State courts are courts of general jurisdiction. If you've got a beef with your neighbor, you file it in a circuit court. It then goes up to a court of appeals, an intermediate court of appeals, and the Wisconsin Supreme Court is a court of last resort. It's a reviewing court. And so here, the proposal that Jensen and Will have submitted would say that the jurisdiction would be only in the Wisconsin Supreme Court. There wouldn't be a chance for fact-finding or trial or discovery or anything in a circuit court, at least until a later, depending on what the Supreme Court decided. But it would go to the Supreme Court first, and that's discretionary. The Supreme Court could decide to turn it down and not take the case at all. So that's an important point about the proposal. Second of all, the process that is proposed in the petition would occur after the legislature has the text of the proposal is that adopted new maps. Now, maybe you've seen some concerns that have been raised in the popular media and by others that one of the things the legislature might try to do is to adopt new legislative districts, not by an act of the legislature, which importantly is subject to the governor's veto power. It has to be presented to the governor. There's a presentment clause in the Constitution that legislation by the legislature has to be presented to the governor for either the governor's signature or veto. But there's also another way that the legislature can act, and that's through a joint resolution. And so this particular proposal by Jensen and Will proposes a process only after the legislature has adopted new maps. It doesn't say anything about enactment. It doesn't say anything about the governor's involvement in that process. So I view this as a Trojan horse provision to try to establish some kind of precedent that the joint resolution is sufficient for redistricting and there doesn't need to be legislation. A third sort of top line point about this petition, I think, is that it proposes a process where there are only a few mandatory parties to this litigation that have to be let in. It's the legislature, it's the governor, and political parties. What do political parties mean? I don't know. Does it mean that if the Communist Party wanted to participate, it must? Maybe it does. But there's no provision, at least no mandatory provision, that allows groups like this group or the League of Women Voters or SEIU or anyone else to participate in this process, in the litigation process. They could file a motion with the court and ask, but they would have to be granted permission by the court. So this, at a time when Wisconsinites are overwhelmingly calling for a nonpartisan redistricting process, we see it from counties across the state. We see it from Charles Franklin's polls that he takes for the Marquette Law School, that 70-something, close to 80% of Wisconsin voters want a nonpartisan process. We see Scott Jensen and Will, who are proposing a hyper-partisan process, which is not what the people of Wisconsin want. And then finally, another top line point is that the proposed process is one that could allow for a decision by the Wisconsin Supreme Court with no hearing, no evidence presented, only on the papers that are submitted by the parties who are the statute would allow must be admitted into the process. And so it really cuts the public out of the process if that's what the Supreme Court decides to do. And let me stop there in the interest of time and turn it over to Jeff for any other comments.
Thanks, Doug. I think you covered it. We only have about 10 minutes left, so I'm going to turn it over or turn it back to Rabbi Margolis, I think, for questions. Is that right?
Hi. Yes, thank you both so much. This was really, really comprehensive and really fascinating and somewhat frustrating. I'm sure you guys were frustrated as the lawyers on these cases. So we have a few questions. Some of them Jeff very valiantly answered in the chat, but not everybody was reading the chat. So if we can just answer them out loud a little bit. So the question early on was asked why the Government Accountability Board was abolished.
Yeah, so in short, the Government Accountability Board was abolished in the wake of the John Doe investigation, which was triggered by allegations of campaign finance violations around and related to Scott Walker's campaign during the recall election. But I think the bigger point that I would want everyone to understand about the Government Accountability Board and sort of the changes. The Government Accountability Board was itself a fairly new idea not that long ago. The idea was to go from the State Elections Board, which we had before, which was a bipartisan institution, to a nonpartisan institution. The Government Accountability Board was comprised of retired judges. And the idea was that these were folks who had run for judgeships and served as judgeships as nonpartisan officials who cared deeply about the state, and that elections could be overseen not on a Democrat-Republican basis, but on a nonpartisan, good government basis. One of the things that's important about this, beyond just the concept that elections should be good for everyone in the state and are not just about winning, but they are about democracy, about bringing people in and together to the process. But one of the things that's important about this is these bipartisan groups, and we'd seen this with the State Elections Board, although it was before my time, they often deadlock, right? The Democrats want one thing, and so the Republicans want something else, and nothing gets done. So the innovation of the Government Accountability Board was really twofold. One was that they were going to get rid of that problem by creating a nonpartisan group instead of a bipartisan group. The other was that they were going to unify elections administration and campaign finance supervision, whereas traditionally those had been done by two different groups. Well, when the Government Accountability Board was really doing its job and pursuing these investigations, it upset some people who were very powerful. At the time, of course, we had unified control here in Wisconsin of the legislature and the governor's office by the Republican Party. They did not like how the Government Accountability Board undertook these investigations. And so what they did was they disbanded the Government Accountability Board. And as I wrote in the chat, everything old is new again. And so we went back, we undid the two new things about the GAB. We separated the election administration from the campaign finance again, so now the Wisconsin Elections Commission oversees our election law, and the Wisconsin Ethics Commission, same acronym, different group of people, oversees our campaign finance rules and our lobbying restrictions. The second way that they did that was that the Elections Commission has 3 Democratic members and 3 Republican members, and it is designed, it's a feature, not a bug, that on anything of any controversy or really of serious import, the Elections Commission deadlocks 3-3 and nothing happens. That's the way that the system has been designed, and our elections are, for the most part, I think, all the poorer for it. Because what it means is the only way you can make serious changes to our election rules, the regulatory body that's overseeing the elections on a day-to-day basis really can't agree on anything and is designed not to agree on anything. So the only way you can make change is through the legislature, through the lawmaking process of bicameralism. It has to pass both houses, presentment, as Doug talked about before, it has to go to the governor. And when it comes to things like COVID-19 or other circumstances that require us to be nimble and try to protect the spirit of our democracy and make sure that people can really participate in our elections, we are caught flat-footed, and the Elections Commission is institutionally, this is not an insult to the people who work there or the people who are on the commission. I want to be clear about that. By design, the Elections Commission is not up to the task. It simply can't be.
Yeah, just very quickly as a follow-up on that, as Jeff said, this was designed by the legislature and Governor Walker to be a feature, not a bug, that the Elections Commission would deadlock on everything. And what this has allowed the legislature to do in conjunction with the lame duck laws, where they took for themselves even more power that previously had resided in the Department of Justice or the Attorney General. And in the governor, they took it for themselves. And so now what we see in these lawsuits, where in the past, the lawsuits have been against the Government Accountability Board, which is in charge of administering elections, now we see the legislature coming into the courts and telling the courts that the legislature wants to be involved in the litigation, that it is the real party in interest, not the Elections Commission, and that it should be the one who should be able to control what happens in the litigation for the state of Wisconsin, not the Elections Commission. So this is really a really a takeover of the entire process, not only of passing the statutes, but also administering elections, at least in terms in these large policy issues by the legislature.
Thank you. That was depressing.
A lot of this is.
Yes. So we have a question. Have there been any incidents in Wisconsin of party observers at polling places acting improperly or too zealously in challenging voters at the polls?
I'm not aware of sort of a concerted effort or particularly egregious repeated conduct, but certainly there are individual moments where people are overzealous. There's a law in Wisconsin, for example, that if you mismark your ballot, you can turn it back in. It's called a spoiled ballot, and they give you another one. But you only get 3. I don't know why that's what the statute says, but that's what the statute says. If you spoil 3 ballots, you're out of luck. I was election observing in Oshkosh in 2016, and I don't know if anyone listening today has had this experience, but sometimes with these electronic voting machines, you stick your ballot in and it rejects it for unknown reasons. There's not really anything that you did wrong with your ballot, but you know, computers can be finicky. Anyone who's tried to put a dollar bill into a vending machine knows that. We had a voter who the machine rejected her ballot 3 times. Now, keep in mind, she hadn't voted yet, right? You put the ballot in and then you vote. And then it spits it back out. So these aren't really spoiled ballots. They're just ballots the machine won't accept, blank ballots the machine won't accept. And there was an election observer who insisted that because it happened 3 times that she'd forfeited her right to vote. And we had to solve that. She actually left the polling place. We had to figure out who it was and track her down and make sure that she knew that she had the opportunity to come back and vote. I don't know of sort of organized in Wisconsin, organized kinds of deliberate intimidation and things. But I do think it happens. Sometimes people are overzealous. Sometimes there are people doing this, and it's an issue.
We do have a very active election protection program, though. I'm not sure how many cities it's active in. It certainly is active in Milwaukee, and it's active in Madison. And so there are lawyers who volunteer their time to be ready to go into the circuit courts and get emergency TROs if necessary, for example, to hold open polling places if there are long lines and those kinds of things. So there are observers, as Jeff said, he functioned as one, and we have election protection. So I don't get the sense that it certainly is a significant and widespread problem.
Great, thank you. So there were a couple of different questions that I'm going to put together around the voter harvesting, the ballot harvesting case. So somebody asked, does that mean if the regulations that Will wants to go through would go through, that you literally have to hand your ballot to the city clerk herself? And then also, does that invalidate the ballot drop boxes that we saw springing up to allow people who are afraid to go to the polling place because of the pandemic, allowing them to drop their ballot into a ballot box?
I mean, these are great questions, and I'm not sure that there are clear answers. What I would say is, if you take literally what the rulemaking petition says, I think this rule would prohibit you from giving your ballot to anyone else other than the city clerk. I don't think it would prohibit drop boxes. I don't think it would prohibit you putting it in the mail, although, you know, putting it in the mail is essentially the same as handing it to the mailman or mailwoman. But I do think that you could understand it, and probably should understand it if it were to be adopted as it's written, to prohibit you from giving it to a poll worker or somebody else who's working at City Hall. With respect to the drop boxes, though, as long as there are drop boxes, and I hope we see more of them, they are allowed by Wisconsin state law. We saw a huge expansion of this due to COVID for the April elections, and I hope it's an expansion we'll continue to see. These are secure, safe places that voters can drop ballots instead of either putting them in the mail. Maybe you don't trust the mail is going to get there fast enough. Remember, most of our mail either goes through Milwaukee and then back to the municipalities where it came from. Like if I mail something in Madison, it goes to Milwaukee before it comes back to Madison. Or if you're on the western side of the state, it goes to the Twin Cities and then comes back. So it's not necessarily a particularly quick process, even if you're just mailing something down the street. So this is a way that you can return a ballot without having to go into your municipal clerk's office, either because you're worried about health and safety or because it's not convenient for you to get there during the hours the clerk's office is open. I hope we'll see a huge expansion of those around the state. I will say, and this ties into another question that came up in the chat about how different municipalities do things differently. That's one of the challenges of having such a decentralized election system. And I do think that there can be ways it's a concern. If we have 50 drop boxes in the city of Madison, and we haven't had that many so far, but you could imagine, and yet there are other places where there are no drop boxes at all, it becomes harder for people in those municipalities to cast their absentee ballot. They have less of an opportunity to vote. And we should be wary of ways that people have differential opportunities just because of where they live. We saw this in April a little bit. There were two suburbs in Milwaukee County, Whitefish Bay and Bayside, that the clerks, and I think this is a great idea, but the clerks took it upon themselves to mail absentee ballot request forms to every registered voter in the municipality. That's a great idea. It helped make sure that people knew how to get an absentee ballot and how to vote. But what about the people in the rest of the state? That seems kind of unfair. I will say some people have misinterpreted what happened in the April 7th election and believe that Whitefish Bay and Bayside, Bayview, I apologize if I'm getting it wrong, that they sent absentee ballots to every voter. They did not. You cannot, a municipal clerk cannot send an absentee ballot to someone in the state of Wisconsin who has not provided voter ID. So thanks, I see it's Bayside. You can't do that. No municipality can simply send ballots to everybody. That would violate the voter ID requirements. But you can send applications, you can send instructions, you can send things that help people understand their rights and cast their votes.
Yeah, and to its credit, I should also point out the Wisconsin Elections Commission is proposing to make exactly that to all registered voters within the state. So that's 2.7 million registered voters in the state are scheduled to receive by mail absentee ballot applications. So kudos to the Elections Commission for doing that. That's one thing that they've definitely gotten right.
Thank you. So there was a little bit of confusion with the voter purge case about exactly how many voters are at risk for being purged right now. So the number that was purged in 2018 is not aggregated with the number that might be purged now, right? That's two separate things.
Leah, let me address that. So what happened in October of 2019, approximately 234,000 registered voters within the state of Wisconsin received this letter, this what we call this ERIC letter, saying we have information that you might have moved. You need to update your registration within 30 days or respond to this postcard. The Elections Commission, they continue to perform their maintenance activities month to month to month to month. And what that means is that as people go on My Vote and they change their registration or they change their registered address, some people die, that number is going to change. And as the result of 2 elections that we had, so we had primary elections in February, and then we had the spring general election in April, that number that had been 230,000 is now down to about 150,000. That's about how many people would now be on the ERIC movers list and potentially would be in danger of having their registration deactivated if the Supreme Court rules as the plaintiffs in the Zignego case are asking.
Great, thank you. Can you address the restriction previously placed on the Republicans around voter intimidation, which has expired, and they're soliciting 50,000 volunteers to assist with the vote in November? What kinds of actions might we see from them?
Yes, there was a consent order, which is a consent decree issued by a federal court that restricted Republican activities in some ways based on past bad behavior. This is not a Wisconsin thing. This was a national issue. That consent decree has been lifted, and that frees up the Republican National Committee and Republican-related organizations to do certain things. And they've been very public that they are planning to deploy a very large number of people to be election observers around the country. And they've also been very public about spending a massive amount of money on election litigation. We didn't really get into this earlier, but in almost all of the election litigation that we've seen in Wisconsin this year, the Republican Party has itself been an active participant. So in the in the case filed by the Democratic National Committee, the Republican National Committee and the Republican Party of Wisconsin showed up. I don't think that's a huge surprise or even that much of a stretch. You've got one side of the fight bringing the lawsuit. You've got the other side that wants to show up and have its say too. But the Republican Party also insisted upon intervening and acting as a participant in the cases brought by the Geer plaintiffs and the Lewis plaintiffs, even though those cases were not partisan. The Republican Party also, I believe, showed up in the Green Bay case, although that case was dismissed so quickly. I don't know if it was ever really decided whether they were supposed to be there or not. And the Republican Party in the Swenson case that Doug and I are working on now, and he talked about some, the Republican Party has filed a motion insisting it should intervene. Our plaintiffs have responded that it's a nonpartisan lawsuit, that the legislature has intervened. As Doug spoke about, the legislature is showing up in all of these cases and trying to say that it, rather than the Elections Commission, is really the proper defender of state law. It's not entirely clear why that's true, but put that aside. They are making that claim, and the Republican Party still insists that notwithstanding the legislature's participation and notwithstanding the absence of the Democratic Party from that lawsuit, it is essential that they participate. And in all of this, they are paying these lawyers substantial fees. A lot of these lawyers, they're paying East Coast fees. These are conservative, high-profile lawyers in the D.C. area, and it's clear that the party has raised and is planning to spend a lot of money to fight. And Wisconsin's only one of the states, but it's pretty high on the list.
Thank you. How successful has the Iowa experiment been with an independent legislative agency responsible for drawing the maps?
Well, I'll just say that if you ask the political scientists who really study this, of the different kinds of nonpartisan redistricting commissions that there are that exist in different states, and it is a state-by-state basis. The different states get to decide how they want to engage in this process. That potentially could change, by the way. There was a House bill, H.R. 1, that passed the House, and that would require for congressional redistricting at least, so the congressional districts only, that redistricting be done by a nonpartisan commission. But that's not law yet. So it's a state-by-state decision about how they're going to handle it. So there are some states, California, Arizona, Iowa's another one, Michigan is one that was recently adopted, where they have commissions. And so the political scientists tend to point to Iowa's as being the most successful. Interestingly enough, in Iowa, they've never had litigation over the districts that have been enacted by their commission, but that's by agreement of the parties. They declared détente that nobody would sue over it, and they've actually observed that. So they haven't had a problem. They haven't had a problem with it at all. So Iowa tends to be seen, at least as of right now, as the I'm not going to say the gold standard, because that would suggest it can't be improved on, but it is seen, I think, as probably the most viable and best operating model of the ones that are out there.
Okay, great. What is the status of One Wisconsin Institute et al. Versus Thompson? Will the appeals court ever issue a decision?
Wish we knew. Just to be clear, so that everybody knows, One Wisconsin Institute versus Thompson is a case. The fact that it's versus Thompson tells you how long ago it was, because at the time that the case was filed, Mark Thompson was the chair of the Elections Commission. So that's why his name is at the top of that one. He was the inaugural chair of the Elections Commission when it was first created. One Wisconsin Institute versus Thompson is a case that was filed here in federal court in Madison, challenging certain aspects of the voter ID requirements and certain aspects of restrictions on early voting that the legislature had adopted. The court ruled partially in favor of One Wisconsin Institute and partially against them. The voter ID requirement largely stands, but there are some student issues that I believe the court got involved in. The court also struck down some restrictions on early voting. So we have more early voting right now in Wisconsin than the statutes actually provide because of the order that the federal district court here in Madison issued in One Wisconsin Institute. The legislature, at that time, Attorney General Schimmel appealed that case up to the Seventh Circuit, and it was argued, I believe, just over 3 years ago now. And it is not normal for the Seventh Circuit Court of Appeals to take 3 years to issue an opinion. Nobody quite knows what's going on. Once the case is argued and submitted to the court, the process becomes pretty opaque, and so I don't think there's any real way for anyone to know what's going on. One thing that could be going on is that courts are generally loath, for good reason, to change the rules right before an election. So the court could be looking for a good opportunity to issue its decision and make clear what the rules are that's not too close to any Wisconsin election. That is a little bit challenging because we have both spring nonpartisan and fall partisan elections in this state. We vote pretty often, but they've had 3 years now. There has to be a time that they could find. Nobody really knows what's up.
Great, thank you. I'm going to let Daniel interject because he has a question from Facebook. Daniel, you have to unmute your...
Yeah, thanks, Bonnie. So 2 questions from Facebook. The first one is, do you think the WEC will send out absentee ballot applications, or will they get hung up on the letter to mail these out?
That's a great question. Somebody's paying really careful attention to what's going on at the Elections Commission. Doug, you want to venture a guess?
Sure. Yeah. No, I think they will. You know, they've committed to doing it. They've committed to sending it out to 2.7 million registered Wisconsin voters. By the way, the chair of the Elections Commission recently switched. It had been a Republican appointee who had chaired it, and that was Dean Knudsen. It's recently switched to Ann Jacobs. She now chairs it. Again, it's a 3-to-3 commission, and so the chair can set the agenda, do things chairs do. Can't order something that the commission doesn't agree on as a whole. But I think they'll get it done. I think they'll agree on the wording, and they'll get those absentee ballots sent out. But you know, that's my belief based on commitments that they've made. And I think that if they don't follow through on that commitment, that is an issue that should outrage every voter in Wisconsin and should really drive people to the polls all the more come August and come November.
You said another question?
I did. So the second question from Facebook was, can we be assured there will be enough polling sites open throughout the state on November 3rd?
Well, I mean, it depends on what you think the word enough means. We held an in-person election on April 7th where a number of municipalities had few voting locations. We had fewer than normal here in Madison, but things went smoothly. In the city of Milwaukee, they had 5 instead of 180. That means more than 97% of the polling places were closed. In the city of Green Bay, they had 2 instead of 31. In the city of Waukesha, they had 1 instead of 17. I would suggest that that's not enough, that we need to do better, and we need to ensure that people have the opportunity to vote in a way that is safe and I hesitate to use the word convenient because, you know, not everything in life has to be convenient, but everyone should have equal opportunity to vote. There shouldn't be huge lines to vote. You shouldn't have to risk your health or the health of your family to vote. You shouldn't be intimidated not to vote or coerced not to vote. And that is part of what we're seeking in the Swenson case, is we are seeking orders that will instruct the Elections Commission to take steps so that local officials both can and must ensure that there are ample polling places in November. But there's so much that's unknown. We don't know what COVID's going to be like. We don't know if the legislature could try to change the law. I mean, there's a tremendous amount of unknown, and so I don't think that at this point in time anyone can guarantee you that there will be sufficient polling places in November. What I think we can guarantee you is that there are a bunch of people paying attention to this, and unlike in April when COVID, you know, really COVID was only at the top of people's minds, and the restrictions and the degree of restrictions in response to COVID were really only fully understood about 2.5 to 3 weeks before the election. We've got a lot of advance notice this time, and people are paying attention, and there's more opportunities to prepare. And that means that there's more obligation on the Elections Commission and municipal election administrators to do a good job preparing and make sure that our election goes more smoothly and we don't see the kinds of disenfranchisement we saw in November.
Mm-hmm. One other quick word about in-person elections. Before the election in April, there was not a tremendous amount of support for in-person elections coming from both of the major political parties. I'm going to be a little bit Pollyannish about this, but in the wake of the April 7th election, given the number of absentee ballots that were returned by mail, and given the overwhelming victory of Joe Korosky in the election against sitting Justice Dan Kelly, in the wake of that election, what we've heard from the Republican members of the Wisconsin Elections Commission is a newfound commitment to ensuring in-person voting and the viability and availability of in-person voting. Now, if they stand by that, and if that is a sincere commitment they have, then I applaud that. because I can tell you that the people that I have represented that get out the vote groups, the community groups, the advocacy organizations that I've represented who have a substantial number of constituents in low-income areas of cities, a substantial number, majority of African-American and Latinx voters, they vote primarily in person. And they are primarily affected by, as Jeff mentioned, these closed polling places in some of our larger cities like Green Bay and Milwaukee and Racine. And so if the Elections Commission, and supported strongly by its Republican members, is going to ensure that there are adequate in-person polling places, then I applaud that tremendously. That's exactly what they should be doing, and I'll hold them to that commitment.
Mm-hmm. Thank you. So we have a few more questions. I'm gonna see how many we can get through. We don't want to run over time. If we don't get to your question, we will make every effort to get it to Doug and to Jeff and have them answer and email you their answer. So there are Fair Maps grassroots teams that have formed throughout the state. They're working on county referenda, political education, and pressuring legislators to adopt a transparent process for redistricting that creates competitive districts and respects communities of interest. In your view, what is their best response to the rules change request?
Well, I think that once we get so first of all, I was also one of the lead lawyers in the Whitford versus Gill redistricting litigation, and I know one of my plaintiffs I see is participating tonight, which is wonderful. We had 40 plaintiffs around the state who participated in that, so it really is a widespread effort. There has been, I will say this, in 2011, during the redistricting that resulted in Act 43, you could have heard a pin drop. There was no attention given to redistricting just about by anybody. Nobody really seemed to care so much. So where we are now, with the tremendous amount of notoriety that redistricting has, the fact that we've got these referenda that are coming up in all of these states or all these counties across the state, the fact that we do have fair maps, we've got all these different groups, it's wonderful to see, it's tremendous. And I think that I would love to see, once we have a schedule that's actually published by the state Supreme Court for submitting comments on this rulemaking petition, I would love to see, and I'd be happy to work with and coordinate with anybody who wants to talk to me about it, would love to see responses submitted to this redistricting petition in terms of the procedures that are going to happen, because whatever happens, we need to make sure that that litigation process is one that allows the people of Wisconsin to finally have a say. In 2011, when Act 43 passed, we had unified government, as Jeff mentioned, in Wisconsin. Republicans controlled the Assembly, the Senate, and the governor's mansion. These maps, as people have probably read, were created in secret by a very small cadre of Republican legislators and consultants. Most sitting Republican legislators didn't know what was going on. They weren't informed. None of the Democrats did. There was a truncated, abbreviated, less than one full day hearing where the people who testified were just sort of handpicked, and then it was just rammed through. The people of Wisconsin had no opportunity, I mean no opportunity, to comment on the districts. That has to be different this time around. It has to change. People should speak up, they should speak often, and they should speak with a loud voice.
Thank you. Is there a legal problem with different city clerks handling mail absentee ballots differently? Specifically, if the city clerk for Milwaukee sends, well, it says an absentee ballot, but let's say an absentee ballot application to every registered voter in the city of Milwaukee, and a city clerk for a different municipality chooses not to do so, is there a legal problem, or can each municipal clerk decide on their own?
Doug, I talked about that a little bit. You want to share your views?
Well, that's okay. No, it's up to the municipalities about what they want to do. And so we had, as Jeff mentioned, there were two municipalities, one where I grew up, Whitefish Bay, which chose to send out the absentee ballot applications on their own. And you know, hopefully, if the state follows through and sends them out to everyone, then that really obviates the need for the municipalities to do it.
Mm-hmm. Right. Okay, so I just have a couple more questions. Are clerks allowed to reject a ballot if signature does not match the one on file? The Wisconsin Election Commission's instructions are ambiguous.
Yeah, so I quickly scribbled out a response to this in the chat. signature matching is actually not one of the requirements for processing an absentee ballot in Wisconsin. There are states that do that. We don't, I think, because the voter ID requirement is so stringent on the front end. There are a lot of things that need to be checked on every absentee ballot, and the clerks report that counting an absentee ballot takes 10 or 15 times as long as counting an in-person ballot because there are so many things that need to be checked, but they don't actually match the signature. That said, I think, and someone can correct me if I'm wrong, but I would imagine there are observers, as were mentioned before. Individual campaigns and political parties are allowed by statute to send observers in when ballots are counted, including absentee ballots. And I think that if the signature on an envelope were to radically depart from the voter's name, you know, if the signature says Santa Claus, or the signature said Michael Jackson, you know, or whatever else, and the voter's name were not anything close to that signature, you might see a challenge on that basis, not because the signature didn't match, but because it appeared that the signature might not be the voter. So please don't play games with your absentee ballots. Please sign your own name. Please make sure everyone you know signs their own name. Please make sure they're properly witnessed. You know, under current Wisconsin law, if your absentee ballot's not counted, you won't know that until 30 or 45 days after the election. That means that all the votes have been finalized and the election is over, and you have no recourse. So you want to make sure that you do everything you can so that your vote counts.
Thank you. Last question. What are the possibilities of letting high school and college students 18 years and older serve as poll workers? Elders have been a staple of poll workers, and COVID and real fears have kept that population from volunteering. What would have to be done to encourage this younger population to serve in this capacity?
Well, I think that, you know, anyone who's 18 or older is eligible to serve as a poll worker. We, and I use that term sort of writ large, we as a society and as a state should be doing what we can, including our municipal election administrators who are in charge of identifying, training, and deploying poll workers. We should be doing what we can to recruit people. We have for a very long time relied disproportionately on our senior citizens to be our poll workers, and COVID has shown that is not always going to be sustainable. I will note, though, that one of the additional challenges with recruiting poll workers, you know, keep in mind that if things are normal, if COVID is not at its height, many of our young people will be in school on election day. And so, you know, high schools usually don't close for election day. College campuses usually don't close for election day. So there are some challenges there. It is not an accident, nor is it illogical that so often our poll workers are our seniors and our retirees. But it doesn't have to be that way. They don't have to be the only ones. I will note that one of the things that's in the Swenson case, there is a little-known provision of Wisconsin election law that prohibits poll workers from working at the polls outside of the county in which they reside. This is a little bit of a complication, and it became a particular complication this past April when we had huge shortages of poll workers in certain municipalities or certain parts of the state. It is an obstacle to our clerks and our elections commission deploying human resources in the most efficient way possible. And that is why in the Swenson case, we have asked the court to suspend the application of that statute for the November elections so that we can make sure that even if there is a surge in COVID, we can take all possible steps to make sure that not only that we have an ample number of polling places, but that those polling places are proportionately distributed around the state so that there is not a disproportionate difficulty in voting for any one group of people, whether that is geographic, racial, ethnic. We can try to make sure that everyone in all over each municipality and all over the state as a whole has an equal, fair, safe, meaningful opportunity to participate in our elections, because that is truly essential.
And Bonnie, if I could just get in one last point on the issue of volunteers, an email landed in my inbox at around 3 o'clock this afternoon, coming from Wisconsin Faith Voices for Justice. It talked about volunteers needed. An email was received from the Madison City Clerk's office asking about help with preparation for absentee ballots for mailing. So perhaps that's something, I don't know if there's any kind of an age restriction with that, but that may be something that, that you want to speak to.
Yes, thank you so much. Those are two fabulous segues. Thank you. So yes, the Dane County or the Madison City Clerk's Office put out a call today through the League of Women Voters for volunteers to help. This week, go to the City County building on Martin Luther King Boulevard. If you did not receive that email, please email Wisconsin Faith Voices for Justice at wifaithvoices4justice@gmail.com. Lauren, could you put that in the chat box for me, please? And we will forward that that email to you. In terms of youth, people 18 and over volunteering, I actually was on a committee the other day with the Madison City Clerk. She was getting input from different community members about making voting more accessible in August and November. And when that question about having young people volunteer at the polls came up. And a couple of suggestions that I made were, first of all, well, obviously it would be nice if Election Day was a federal holiday and we all had the day off. Failing that, if the work shift could be from starting at 3 o'clock or at 4 o'clock so that the 18-year-olds can get out of school on time and then be able to get to the polling place where they're assigned to work. And also a lot of high school students these days are required to have community service points. And if this could be a way for them to make some of their community service points, that would be an incentive for them to volunteer, or I could also get paid. So, which leads me into the work of the Wisconsin, Interfaith Voter Engagement Campaign, which Wisconsin Faith Voices for Justice and Wisconsin Council of Churches are partnering on this year. We are going to be hiring local organizers in different locations around the state very shortly. And one of their tasks is going to be to reach out to our partner congregations and organizations and to recruit new congregations and organizations to partner with us. And part of that will be an outreach to congregations' youth groups and to college campuses and to high schools to get young people registered and get them engaged in voting, but also to get them engaged in doing some of the organizing work with us and potentially becoming poll workers. So that's definitely on our radar as something that we want to be working on. Please do visit the campaign's website. It's interfaithvotewi.org. It's in the chat box. Peter, do you want to say any last words? You have to unmute yourself.
Oh, I can't.
There you go.
Yeah, thanks. No, I think those are all great points. And yeah, we certainly encourage people to learn more about the campaign, to get involved any way they can, think about what they can do within their congregation or their community, how they can connect with other faith groups, other traditions in their community, and organizations that are working on voter engagement and get out the vote activities. And you know, I think this has been a great webinar to really you know, lay out some of the issues that are kind of all hidden under the surface of you know, what sometimes seems like a fairly routine practice of voting when the elections come around. So I'm very grateful to Doug and Jeff for all that they've given us and for their time.
Yes, thank you both so much. Doug and Jeff brought this idea to us and said, would this be interesting for a webinar? Do you think anybody would want to listen? And we said, yes, absolutely. So thank you both so much for your work, for your passion, your commitment, and for sharing all of that with us tonight. This webinar has been recorded. It's also on Facebook, on Wisconsin Faith Voices for Justice's Facebook page. We will be sending out the link. Please share it with anybody you think would be interested. And look out for more emails from us with upcoming events and activities for the Wisconsin Interfaith Voter Engagement Campaign. Thank you all. Thank you all so very much. Thank you to Lauren and Daniel for your tech help and support. And we will be in touch with everybody. Have a wonderful evening, everyone.
Thanks for having us.
Thanks for having us. Good night.
Good night.
Thanks, everybody.